Hello, everyone, and welcome to today's CPD on the Planning and Development Act. Our speakers today are Suzanne Murray and Brendan Slattery. Brendan will speak first, followed by Suzanne, and I would like to just introduce them both briefly. Suzanne is Senior Counsel, specialising in areas of planning and environmental law, and she is also a qualified town planner and member of the Irish Planning Institute. Suzanne has advised and acted for private clients, the state, An Bord Pleanála and the Environmental Protection Agency. Brendan Slattery is a planning lawyer and he leads the team at McCann Fitzgerald. Brendan has almost 20 years of experience in areas of environmental planning and climate change. Brendan is a recognised expert in both planning and environmental law at national and EU level. So welcome you both and thank you both for your time today. So Brendan will present first, followed by Suzanne, and we will do questions. If you have any questions, please put them into the questions and section of the, you can type them in and we will take questions at the very end. Both speakers will speak for about 20 minutes each and then we will have time for questions. Thank you both.
Super. Good morning and thank you very much. Myself and Suzanne have discussed what we think are the most important things to chartered property, land and construction surveyors and hope to highlight those during this session. There's a lot to cover, so I'll jump right in. Just to remind ourselves why it is we have conducted a reform of planning law. Before 2 elections ago, then Minister for Housing Eoghan Murphy had proposed reforms relating to judicial review because there was anxiety about the way the High Court was approaching and dealing with legal challenges to planning permissions. He didn't quite anticipate what was coming next, but what came next is probably the busiest era of legal challenge to planning decisions in the history of planning in Ireland. And to take a data set snapshot, if we look at the almost 100 cases concluded in the year 2023, which is the last year for which there's full data reported by An Bord Pleanála, you can see that fewer than a third actually reach the finish line of a contest. And of those that do, a large number are lost by An Bord Pleanála. But the bigger numbers of concern are the almost 40 of the 100 odd cases are conceded. In other words, the board identifies a legal error that's not prepared to defend in court, or another 28 that are withdrawn. And we know the vast bulk of those are withdrawn because there's anxiety on the part of participants that the case will be lost or conceded. And so the risk is managed by private agreement. Against that background, the Attorney General began a review process for the reform of planning law that has taken some time to reach its conclusion. It is now past the Dáil, past the Seanad, and signed by the President, and part of it is in force, but the vast bulk is not yet in force, does not yet have legal consequences. The parts that are in force concern the rent pressure zone in Drogheda, the owner's management company changes that are necessary for the Land Development Agency to take over in relation to social housing projects. Those are the only parts currently in force. We do have an indication of when the rest will come in force. We've been told, obviously, by the Programme for Government that one of the many objectives of the newly formed government is to implement the Planning and Development Act 2024. And Assistant Secretary General from the department has explained the basic structure of how the department, the permanent government, sees itself giving effect to the commencement of the Act. And it's expected to take of the order of about 15 months to bring the entire of the law into legal force. First thing, before I come to that expected programme, obviously, nothing survives contact with the new minister. So Minister Brown, as Minister for Housing, may well have different views on pace. Certainly this can be brought into force more swiftly than is currently programmed, but I think it will take the bulk of this time. First thing we know is the department has prepared a commencement order to commence about 80 of the sections in the Act, which would include the retitling of An Bord Pleanála to An Comisiún Pleanála. And for example, we've been mocking it maybe that events and fun fairs, the change in regulation on those will be among the early ones brought into force. I think with the completion of the Lorna Lynch review in relation to the period of the board from 2022 to 2023-24, and the number of board members that are now different from that era, in particular, that there'll be an enthusiasm to maybe retitle the board. And so we should expect that during Q1 of this year. The next phase of implementation we're expecting is the reshaping around forward planning, the new national planning framework, and the new concept of national planning statements, which I'll come back to, and effectively the plan setting framework issues. So we should expect those during the second quarter of this year. During that same quarter, we should also expect consultation on exempted development. When you go through the new Planning Act, you will not find an equivalent to the old Section 4, those exemptions for improvements to structures, those exemptions for use and curtilage. Those are no longer contained within the Act. They're shifted to, are expected to be shifted to, the planning regulations, into the old Schedule 2 of what we have of the current planning regulations, and expect consultation on that in terms of what are the kinds of exemptions we should expect to see, and expect also consultation on the project type classes and thresholds for environmental impact assessment. If you're among the cohort who's pressing for groundwater boreholes of less than a given number of megalitres to be fully screened out from EIA, not required to be the subject of even screening determinations, that consultation's coming soon, but certainly at some stage before the half year. The changes around consenting, and Suzanne will be coming to elaborate some of those features, moving us to the standard application, which we know as the Section 34 application now, or direct applications to the board, which encompasses the bundle of what we call today strategic infrastructure, the new process around alterations and extensions, or the new public authority consent application processes. We're not expecting those to come into force until the back end of this year, and that's probably at the earliest, with judicial review reform and cost protection reform coming after that. So at some stage in Q1 2026. That might be accelerated, but that's the current thinking. Why might it be slow? Because we can't really make those changes to the planning application consent framework until we have the planning regulations in play. And in fact, much of the changes are dependent on new planning regulations. And it's not a simple matter of simply tweaking some cross references in the 2001 regulations as amended. It was expected that a set of draft regulations would be published for consultation and awareness before the bill was enacted, and that was promised in the Dáil debates, and that promise failed. We're expecting drafts to issue to trusted bodies like yourselves, the Irish Planning Institute and others, at some stage during the first half of the year. Come to more the substantive themes now, and just to pick a thread around how this is a reform that has taken some time and will continue to take some time to have legal effect, which is dealing with issues that were pain points or friction in the planning process from 3, 4, and 5 years ago. One of those was around the status of Section 28 guidelines issued by the Minister, whether regulating on height or compact settlements or other features of density and sustainable rural communities and the like. Those guidelines were under attack, and you see here a chronology of a court case that's ended in the Supreme Court recently last summer. But the concerns and issues it dealt with have been live in that court process for the better part of 3 years. The Planning Act fixed that problem. Turns out they didn't need to. The Supreme Court has said actually the existing law was okay. But how are we fixing that problem? We're taking the old Section 28 guidelines. We are enumerating in more detail in the Act the kind of thoughts that must be considered before those guidelines can be made. We're sharing responsibility with wider government, making sure that these are signed off at a Oireachtas level, and we're splitting them into new labels. So we'll be dealing with national planning policy statements, which will contain national planning policies and measures. Those NPPMs will be our new acronym for what we used to get excited about in specific planning policy requirements of the Section 28 guidelines. Those will be the features of the top-down rule setting by government with which material consistency must be demonstrated throughout the entire planning hierarchy, all the way through the regional spatial economic strategies, development plans, the area plans as retitled, and Suzanne will be coming to those. They'll require material consistency with those national planning policy statements, the policies and measures within them. There'll then also be planning policy guidance, and that'll be more around methodology. There won't be requirement for plans and other decision making to be consistent with those. They merely have to take due account. So they'll be splitting what we know as the Section 28 guidelines into just the important part, like the SPPR, and then the rest that's maybe more scene setting and context other guidance. Suzanne will be dealing with the changes around development plan making and area plans. I just wanted to highlight one issue around transition. And many of you will be aware of the friction in the County of Wicklow around recent decisions to refuse large-scale residential development applications, both of which are now under legal challenge, where An Bord Pleanála refused to grant LRD permission in circumstances where a town plan or a local area plan had expired. When you look across the Eastern Midland region, and that's the not very legible Excel spreadsheet to the left of this slide, shows the better part of about between a 35 and 40% of LAPs in that area are expired. And we have Bord Pleanála making clear it won't grant consent for LRD permissions on the basis that it's not zone land and or that there's a prematurity pending the new plan. That puts pressures on local authorities to get on with making such plans. But if they don't make them by the time Section 81 comes into force, they'll have wasted their time. And so now there's a tension between when Section 81 comes into force. Now, what does Section 81 say? It says local area plans made before it comes into force continue to survive afterwards. But if the plan hasn't been made in advance of this coming into force, all the work that's been done is set at naught. And so there's pressure within the Local Government Managers Association, the city and county managers, around when it is this is brought into force and whether it's worth their while picking up all the slack that's now a pain point and problem on large-scale residential development, or whether they should wait for the new legislation. It's a real problem. The minister needs to nip in the bud immediately within the first, I would say not 100 days, within the first 10 days of office. Suzanne will outline some more important features of the consent process. There are a couple I just wanted to pick up that echo from what I've just said about the local area plans. One is there's a helpful improvement, hence the green light in my traffic light symbol, that says planning authorities and Bord Pleanála won't be able to refuse permission by reason that an area plan hasn't yet been made, unless the development plan calls it out in express terms. So we won't suffer that kind of prematurity complaint we're seeing in Rathnew and Blessington, for example. Also, we have an express provision that says those settlement targets, housing growth targets identified in core strategy shouldn't be relied upon as a reason for refusal. If you think about the suggestion that Greystones and an application for 99 units in Greystones should be refused because Greystones is already full, this provision is a direct response to that frankly embarrassing decision. It's not all good news in terms of tweaks on the consent process, and one feature is a response to, again, litigation that's been ongoing, where judgment was reserved in 2 cases in February of last year, where judgment is still awaited 11 months later, around the extent to which Bord Pleanála on appeal is free to amend a scheme, in this case by removing floors by way of height from a scheme in order to ensure compliance with a development plan or national policy. And what the Act in the 2024 Act now says is that there will be an additional control on the board that requires, when they are dealing with an appeal and a request by a developer on a first party appeal to deal with a modified scheme, that it has to be substantially the same development or proposed development to which the local authority decision relates. So the flexibility for developers on an appeal against refusal by the local authority, a first party appeal, to offer up or sacrifice features in their development is going to be materially constrained under the Act. Touch on judicial review reform, and I know it's a pain point, I suppose, just to acknowledge the planning system processes 30,000 decisions in a calendar year, and Bord Pleanála gets to deal with about 3,000 of those. It's about 100, 150 that are ending up in court. Now, those are big numbers. 10 years ago, when I was doing the work of An Bord Pleanála, there were 15 challenges to the board in a calendar year. Now we're pushing on to 150. We've an order of magnitude change. When this planning bill was introduced, there was much said about how it will make judicial review better. how it'll make it more difficult to bring legal challenges, how it'll make it more difficult for courts to find against An Bord Pleanála and deprive people of planning permissions granted. And the reason for the big red circle with a line through it, because most of that hasn't survived the lawmaking process or wasn't true when it was first said. So when Micheál Martin stepped out of the Ardèche a year ago and said anyone objecting to offshore wind farms off the east coast will want to have a view of it or be living nearby before their complaint will be taken seriously in court, that's just not true. The suggestion that Bord Pleanála would spy challenges coming or receive challenges and then immediately amend their decision to resolve the complaint made promptly and spare a planning decision from legal risk, again, that was utterly diluted by the time the Act has come into place. The range of strict timelines that were imposed in the draft law, the bill-making stage, have all been removed, presumably upon feedback from the court service and the planning court list, to say it's not appropriate for an Act to include strict timelines. I might just pause on that. There's a wind farm that will soon be the subject of a hearing on a second planning permission process, but an original permission is still extant, was challenged in proceedings heard in February and March 2020, before we went into lockdown, before the schools had even shut, and we're still awaiting judgment. I think there is something there, and maybe insisting that courts deliver judgments a bit more promptly, because frankly, 5 years of a 10-year life of permission trapped in court waiting for judgment is something the state can and should be embarrassed about. Much is said about residents' associations. When you read the amendments to the judicial review process in whole, what you will see is, in fact, if an organization makes submissions and raises points, and those points lead to legal errors, it's not going to be difficult for them to bring court proceedings. For most residents' association who are well advised, it will not be difficult for them to fashion themselves in an appropriate manner to allow them bring challenges. In my view, the changes made, if I look across, take the last 100 judicial reviews that have passed across my desk here in McCann Fitzgerald, I would say there's only 2 of them might be affected by the change that have been made. In other words, every one of those challenges could still be brought under these new provisions, even though they ostensibly seem more strict. And the only 2 that are different is because there's a change around amending proceedings. In there you have Bartra's co-living scheme up near Connolly Hospital and the Hines project on Clonliffe Road. Both of those were successfully challenged by an object or applicant in legal challenge proceedings who amended their proceedings after launching their case to include additional grounds for challenge, which under the new Act would be more difficult to do, but under the old Act was not difficult to do. And I think those are the only 2 permissions, I think, that might be dealt with differently as a consequence of these judicial review changes. Perhaps the most important change, which some have described as like a knife through butter of the legal market for legal challenges to permissions, is the potential reform. And as you know, at the minute, the rule is that, how I might describe it, heads I win, tails you lose. A person bringing a legal challenge is confident knowing that they will not have to pay their opponent's legal bill if they lose. If the developer, Bord Pleanála, and the state are successful in defending a permission, the costs bill stays with the developer, the state, and on Bord Pleanála, they pay for their own legal bill, and the objector pays their own legal bill, whether that might be no fault, no fee, or whatever. If the objector wins, on the other hand, they will have an opponent who will have to pay their legal bills. So it's all good news for them. The change that's contemplated by the Act is that there'll be a cap put on recovery. So instead of being able to recover 150 to 200,000 euros from An Bord Pleanála when you're successful in a challenge, you might be capped out at something like 35,000 euros. And so there's an economic disincentive. However, it's not all good news. First of all, there's a lot of friction around whether that could lawfully be imposed, and some doubt about whether there's enthusiasm within permanent government for actually doing it. And second, there's a a boondoggle of a scheme proposed by way of legal aid that will fund losing challenges too. So the idea being we should have a community of active legal challenge, and that should be contributed to by the state. So money set aside to encourage legal challenges. The full detail of that scheme is yet to be described. Darragh O'Brien, while he was minister, remarked about that €35,000 threshold comparing to the UK. It's not really working very well in the UK, so I wonder about that. And the hospital pass signal at the bottom is that the Department of the Environment has been tasked with this legal aid scheme, and there is no enthusiasm within that department for actually introducing it. So watch this space. Some of the features of this act may well be amended or never brought into force before we see the light of day. Allied to the reform on judicial review, the sensitivity post that primetime special sees a new criminal offence regarding making requests for payment in order to withdraw planning submissions or withdraw appeals or withdraw legal challenge, or even to promise not to bring legal challenge. There is still the prospect of requesting compensation for rights interfered with, and there's still the prospect of a developer making a proposal should they choose and wish. One thing people have been sore about in judicial review, and think of high profile examples, where at the tail end of winning the process, you might have burned between 1.5 years and 2.5 years in court. And that's frustrating, and you don't get that time back easily. Well, this new act answers that by saying a developer can, upon receipt of a legal challenge, request and notify the parties that he will pause their planning permission. Extensions of duration, and that's where the friction arises. And there'll just be a couple of minutes closing some of the smaller features here. I'm sorry, Philip has raised his hand, but I don't know if that means there's a problem with my connection. If there is, can someone else shout and tell me there is? Otherwise, I'll assume queries will arise.
No, it sounds fine,
Brendan. Okay, that's fine. On section 42, currently under the Act, we can get extensions to the duration or life of a planning permission by establishing substantial works. That's fundamentally changed under the new Act. You will establish your right to an extension through a process that will feel more like a mini planning application process. But importantly, even as soon as this provision, section 140, is brought in, the old rules on substantial works will continue to apply to permissions granted under the old Act for 3 years. And so anyone who's looking at, for example, any of the SHD permissions and the like that were granted and looking at the possibilities of extension duration on those, none of them will be able to take the benefit of the new clause. Instead, they will have to establish substantial work. So that's part of that transitional method. The helpful amendments that came into force in 2021, introducing the 2018 Act around compliance submissions, where the local authority is deemed to have agreed with your proposal if they are silent or don't come back within 8 weeks. That's reversed. Instead, it'll be deemed not to have been agreed, and you'll have an appeal right to An Bord Pleanála. I think that's a real backward step. Hopefully there's some appetite to change that before it's brought into force. Section 5 declarations have been materially changed. There was a pain point in Section 5. It was dealing with maybe too much heavy lifting, but it still carried enormous weight. A declaration carried enormous weight in the planning process in the event of enforcement. EirGrid, ESB Networks have happily defended from enforcement proceedings upgrades to power lines in Kildare and nationwide on the basis of having a Section 5 declaration. The process is materially different under the new Act. The number of people who can make the request is dramatically reduced, and it's not for the public any longer. And when a Section 5 declaration, as it'll be under the new Act, Section 9 declaration, is obtained, you can't rely upon it in legal proceedings, save to just bind the hands of the local authority. In other words, if a developer gets a declaration that something is not development or is exempt development to take international protection or emergency homeless accommodation, and gets one from a local authority that says you're grand, you don't need planning permission, that won't bind the neighbours. The neighbours will be free to bring enforcement proceedings unconstrained by the comfort you draw from the Section 5 declaration. The best good news, though, is that the cohort within An Bord Pleanála has built up, that the vast bulk of them have long duration appointments, and they're churning out decisions at a great rate, which is about the main antidote to anything that we have to complain about in the planning process. I'll hesitate now. and give Suzanne a chance to take over and give you some real detail.
Thank you, Brendan. Suzanne, you're on mute. Just to unmute yourself. Yeah, great. Thank you.
Hi, everybody. First of all, I'd like to thank the Society for inviting me to speak here this morning. And obviously, following Brendan is always a hard act. But I want to just talk about some various aspects of the plan. There's more detail on the slides. But I'm going to cover the new provisions in relation to the development plans. What are going to be different types of local plans. So there's a plethora of plans under the development plans that we all need to get to grips with. I'm going to look at some of the features of what I call the normal consent process. So this is the normal section, what is now a Section 34 planning application. I'll also look at some features in relation to material contravention. While it's still there, the procedure has changed, particularly at the board level. And I'm also going to look at what the time limits now are going to be imposed on the board, or now will be known as the Commission, in terms of determining planning appeals, which is a big change from what we have at the moment in time. So if we look at development plans, firstly, as you know, development plans currently have a lifespan of 6 years. They're reviewed after 4 years with a 2-year period then to make the development plan. That's now going to be changed, and development plans are now going to have a lifespan of 10 years, and they're going to have effect for 10 years. The review is still going to take 2 years. So once a development plan has been in place for 8 years, the review will commence, and the planning authority will have a 2-year period to make that plan. There is I suppose, a substantial change in the Act, in the new Act, which allows that for the minister to extend the life of a development plan, and he can do that for a period of no more than 2 years. Now, that extension can only be done where he's requested by the chief executive of the planning authority to extend the life of the plan, and the minister has to be satisfied that there are exceptional circumstances which exist warranting that extension. So in theory, we could see development plans which are in place for 12 years, which is twice the lifetime of the current development plan, which is quite a significant change in terms of the life of the plan. Now, obviously, there is still a procedure in the Act to vary the plan, so that still is there. But a 12-year plan, or up to a 12-year plan, is quite a significant departure. The content of the development plan is also slightly differently laid out in the new Act. So you no longer have an equivalent to what would be Section 10 of the Act, of the current Act, setting out the information which is to be contained in a plan. Instead, you have in Section 43 what the development plan has to contain, and it refers back to what are called strategies and statements. So the development plan, as we know it, is going to, I think, change quite fundamentally. It's going to be certainly much, much larger. It's certainly going to be a larger document than the one that we are currently familiar with. And the 2-year time period is going to be, I think, quite a time period, quite a short time span for the local authority to prepare all of these strategies and statements that are required. Now, obviously, we assume that there will be some type of guidelines or guidance issued from the department in terms of the new development plan. So we'll have to wait and see exactly how the department envisage these development plans. But certainly what the Act provides is that the development plan now has to set out an integrated overall strategy for proper planning and sustainable development. Then it has to include these strategies and statements prepared under sections 44 to 51 of the 2024 Act. You have objectives for the promotion, management and protection of areas and structures that are relevant to the implementation of those strategies. There are also then settlement specific objectives that the planning authority has to prepare. And we still have the record of protected structures, so that hasn't changed. That's probably one of the only things that hasn't changed in the development plan. It's still envisaged that there will be a written statement and then a map, and the statement will explain how the development plan is implementing the national planning framework and also the regional strategies. as Brendan said earlier on, what are currently the Section 28 guidelines, these are going to be phased out and they'll be replaced by what are now termed national planning policies and measures. So the development plan will have to contain a statement as to how those national planning policies are being implemented. Development plans are also going to be different depending on whether it's a development plan for a city or a development plan for an area that doesn't include a city. So you're going to have what is termed a settlement strategy for the city. And then in other development plans, which don't consist solely of a city, you're going to have what's termed a settlement hierarchy. So there will be differences between the development plans in terms of whether they're a city plan or if I can just use the term loosely, a rural plan. In terms of zoning, the development plan will still zone land, but there is a slight departure again from the 2000 Act, which provides for the zoning of land where the planning authority consider it necessary, under the 2024 Act, a requirement that the zoning map illustrates the zoning objectives applicable to all land in the functional area of the planning authority. Now, the reference to all land would imply that all parcels of land or all swathes of land will have to have some type of zoning objective, and whether that be rural or what would kind of be commonly known as a white land zoning will have to be seen whether that's going to be sufficient, or whether you need to have residential, industrial, and all the different types of land use zonings applied to the land. So this is a bit of a departure from what we currently see in development plans, where not all land is actually zoned. Again, there's still going to be a presumption that the zoning of land in one development plan, it doesn't necessarily mean that that's going to be carried forward to the next plan. And that's something that is already in place under the 2000 Act. So it's not a huge, big departure there. Again, the plan has to show how it coordinates land use with existing and planned investment in infrastructure and services. It has to show how it provides a coherent and integrated framework for the implementation of these strategies and statements, which now the development plan has to include. Again, how the development plan is coordinated with adjoining planning authorities. There's nothing new in that, that's in the current Act as is. And also how the development plan takes account of relevant transport strategies which have been published by the NTA. One of the other key features of the new Act is a great emphasis has been now placed on the Climate Act 2015, and the development plan has to incorporate objectives to conserve and protect the environment, with particular emphasis on the Climate Act. And this is something that you'll see more in both the development plans, and it will be a feature indeed of determining planning applications and determining appeals, this whole issue of compliance with the Climate Act. I'm not going to go through these in any great detail, but they're set out in the slides. But these are the different type of strategies and statements that the development plan now has to contain. So one is a strategy for sustainable development and regeneration. There's a strategy for economic development. There's a housing development strategy. And again, this differs depending on whether the planning authority consists solely of a city, or whether it's the other type of planning authority, i.e. one that doesn't consist solely of a city. There's also strategy relating to creation, improvement, and preservation of sustainable places and communities. Then a strategy relating to environment and climate change. Again, the emphasis we see here being placed on the Climate Act of 2015. There's a strategy relating to the conservation of the natural and built heritage. And then there's a development management strategy. So this is the likes of your density, your plot ratio, site coverage, and the like. There are also then a settlement specific objectives. So even that just gives you a feel for the kind of the scale that a development plan is going to be. And presumably this is one of the reasons why the life of the development plan has been extended to 10 years, because it's going to be probably a lot more detailed than what we currently see. And therefore, the view is that, well, they should be in place for longer. It also will have implications, or the fact that it's a 10-year period also means that it can probably be more up to date in terms of the census population and the census statistics, because it's not going to be for a 6-year period, which can miss a census. This will be in force for the 10-year period, which is, and as I said, the minister can, if requested, extend that for a further 2 years. We also see a big change in terms of the different types of plans that are going to be under a development plan. So at the moment in time, there's a local area plan, and the planning authority have to prepare those for certain areas. And then for other areas, there's they have a discretion as to whether they're going to prepare them. But local area plans are going to be replaced by in effect, 3 different types of sub-plans under the development plan. And these are urban area plans, priority area plans, and coordinated area plans. Now, the Act does say that a settlement can only be the subject of one of those types of plans. So it can either only be an urban area plan or a priority plan or a coordinated plan. You're not going to have a settlement which is the subject to 2 of them or to 3 of them. There's also express provision that if there's a conflict between any of those plans and the development plan, then the provision of the UAP, the PAP or the CAP will cease to have effect. Again, the urban area plans and the priority area plans will remain in force for 10 years or until the development plan, which required that they be prepared, is replaced. And where a new development plan is prepared after the coming into effect of a UAP or a PAP, the development plan can provide that the UAP or the PAP shall continue to have effect for a period of 10 years. So again, it's this idea that the UAP and the PAP can be their life can be extended. Now, that already exists for local area plans, provided certain criteria are met. But here you're going to see that the UAP and the PAP, they can be extended so as they will actually meet the life of the new development plan. So they could be in force for quite a while. Now, in order for that to occur, there has to be certain criteria that have to be met. And the UAP and the PAP have to remain materially consistent with the settlement objectives in the development plan, materially consistent with the zoning objectives in the plan, materially consistent with the integrated overall strategy for development, and materially consistent with the strategies and statements. And then it also has to continue to take account of the relevant transport strategy. Just on this, we're seeing a new terminology being used in the Act. So at the moment in time, the phrase is usually, you have to have regard to something, or it has to be consistent insofar as practicable with. And the have regard to has always been considered to be a very lightweight threshold. It means you have to consider it, but you're entitled to depart from it if there is valid reasons for doing so. And we have a shift away from that now to this phrase, remain materially consistent with, which has to be considered to be a higher threshold or a higher burden on the planning authority. And that's because obviously it's consistency with implies a greater degree of kind of complying with, but also it's different to the formula used in terms of the transport strategy, which is simply to take due account of. So the transport strategy doesn't have the high standing as, say, the zoning objectives or the settlement objectives. Now, this is obviously something, and indeed this may be something, the meaning of these phrases may well have to be the subject of some judicial interpretation. But this is the way the Act is moving, and we see it in various sections of the Act, to move away from have regard to materially consistent or to take due account of. The UAP, the PAP and the CAP, they can all be amended and they can all be revoked. Again, the CAP is to remain in force for 10 years or until what's termed the principal planning authority makes a new development plan. In a moment, I'll look at the CAP in a bit more detail, but the urban area plans, just to show you how these are supposed to work in practice, the development plan will identify settlements which it considers require what's called an urban area plan. And urban area plans are going to be for settlements. They will be for an entire settlement. So they will be for a larger area. Underneath that, then, you're going to have priority area plans, which again will be identified in development plans, but the priority area plan will relate to a part of a settlement. So your urban area plans are going to be for the entire settlement. A development plan will then be for an identified part of a settlement. So they will be generally be of a smaller scale. That's completely different then to a coordinated area plan, because these aren't designated in a development plan. They're actually designated in the regional strategy. And the areas to which a coordinated area plan will relate are settlements that actually straddle two planning authorities. And then the regional assembly has identified that that particular settlement is important to population growth or employment growth of one or more of the planning authorities. And this is why you have, in the context of the coordinated plans, what's called the principal planning authority and then the associated planning authority. So the principal planning authority are again defined and designated in the regional strategy, and it has to do with the amount of the settlement that's located in that principal planning authority. So the bigger area will be the principal planning authority, then with the associated planning authority, which will have the smaller, geographical area for this coordinated area plan. Now, so this is again, the coordinated area plan is a big departure because you don't usually see the regional strategies actually identifying particular settlements that then a plan has to be prepared for by the actual planning authority itself. So this again is quite a new departure, I think, from what we have currently at the moment in time. Just moving on then to the consent process. And what I want to look at is the standard. So this is what I would term your normal, what is now a Section 34 planning application. And the key differences that I see it is that, first of all, there's now mandatory pre-application consultation for certain developments. And these are listed in Section 89. So if your development is more than 10 housing units, it's a student accommodation, I think, of more than 200 bed spaces, development other than residential containing not less than 1,000 square meters of gross floor space, or such other developments as may be prescribed, and they'll be prescribed in regulations, then you have to have a mandatory pre-app consultation with the local authority. The Act still provides for large-scale residential development, and they're still required to have a pre-app, and they're also still required to have the LRD opinion. So there's been no change to those particular to the requirements under the LRD, but this introduction of mandatory pre-apps for certain types of development is something new. The other new aspect of the Act, and this is something I think which again has been brought about through judgments, I suppose, in particularly a case in relation to a wind farm, and this is this idea that a developer may not know all aspects of the development when they apply for planning permission. And there's now an express provision in the Act which allows you to apply for development where all aspects of the development haven't actually been nailed down. Where this occurs, the applicant can request a pre-application meeting with the planning authority. And that request has to include a description of the aspects falling within a specified category of the proposed development that are not likely to be confirmed by the time the application is made, and also setting out the circumstances that would justify making the application before the confirmation of those aspects. They also have to give an undertaking that in relation to each aspect of the development that is not likely to be confirmed, that they will include in the application a description of not less than 2 approaches, or a statement of the range within which each such aspect falls. So this will, I think, typically be used for things like wind farm developments, where when you're applying for permission, because of the technology changing so much, you mightn't have actually set upon a particular turbine that you're going to use. So you will say, well, there's a range of turbine heights that we reckon will be on the market. They will have a hub height of X with a rotor blade diameter of Y, and this will be the range that we think our turbines will be within. And so that will be specified. So you will give maybe 2 or 3 different types of turbines, and you'll assess those in terms of shadow flicker, noise, impact on visual impact, and impact on birds, or whatever the case may be. So you'll have assessed the range that may ultimately be granted or might, and then ultimately implemented. Again, the planning authority have to give, after having that meeting, they then have to give an opinion as to whether or not the application can be made with these aspects of development not known, or advise the applicant that it's not satisfied to give that opinion. The opinion has to specify the aspects of the proposed development that may be confirmed after the making of the application. So, for example, the height of the turbines, the circumstances relating to the proposed development that justify the making of the application before the confirmation of those aspects, and that the application shall include the description or statement referred to in the undertaking, i.e. they have to carry out the assessments on the various different types of turbines that they may have specified in their pre-app consultation. Like with the current, I suppose, regime, an awful lot of the detail in terms of the information to be submitted with the planning application, we just don't know that at the moment in time. We're going to have to wait for the regulations to come out, and all that detail in relation to the scale of the drawings, what has to be shown in the drawings and the like, will be contained in the regulations. Again, as is currently, the local authority are permitted to grant permission subject to modifications and conditions. They can grant permission in respect of part of the development, subject to modifications and conditions, or they can refuse. The conditions, again, are set out in section 87, and there's a similar list of the conditions that you see in section 34(4) of the 2000 Act. They can also expressly attach conditions for the purposes of EIA and for the purposes of appropriate assessment, i.e. any commitments or mitigation measures that are specified in the NIS or in the EIA can be included as conditions on the grant of permission. And in the case of a development where certain aspects are not known, specific conditions have to be attached. And the conditions are requiring that each aspect of the proposed development that are not known be limited to such proposed approaches as were included in the planning application, or fall within such range specified in the statement included in the planning application. So that requirement then will make sure that it's only something which has been assessed, and this range that has been assessed, or this different type that have been assessed, which will ultimately be implemented or be constructed. And as I said, the conditions that are currently found in section 34(4), you'll find those in section 87(3) of the 2024 Act. In terms of the material contravention is still provided for. The requirement is that the planning authority refuse permission for a development that materially contravenes the development plan, but they can, by resolution, grant permission if it considers that the grant of permission is necessary or justified, having regard to the proper planning and sustainable development, and the development is consistent with provisions of the National Planning Framework, these new planning policies and measures, or RSCSs. So there's no really huge change there. Again, the quorum is still 3/4 of the elected members have to vote for the material contravention, and still public notice is given of the local authority's intent to grant permission by way of material contravention, thereby allowing people make submissions before the ultimate vote is taken by the councillors. What has changed slightly is the material contravention procedure before the board. So again, the Act provides that the Commission shall refuse permission for a development that materially contravenes the development plan, and then gives them the power to grant permission and material contravention if it's satisfied that the development is of strategic or national importance, having regard to the policy of the government, the development plan contains objectives that conflict with each other, are ambiguous, or the development is consistent with the provisions of the NPF, national planning policies and measures. Now, one change this is a slight change, because under the current Act, these criteria that the board have to be satisfied in order to grant material contravention only arise where the planning authority have themselves refused permission on the basis that it's a material contravention, and the board actually agree that it's a material contravention. That extra layer is no longer included in the 2024 Act, and it appears that in any case where the board considers that there's a material contravention and they still want to grant permission, they have to give one of these reasons. So they're not reliant on the planning authority having first refused on a MACCON basis. That provision has been stripped out of the Act. Secondly, and I think more fundamentally, if the Commission is now intending to grant permission in material contravention, they have to give notice of their intention to do that, and they have to provide for submissions to be made in respect of that proposal to grant by way of a MACCON. People can make submissions, and then the Commission has to take those submissions into account before they actually decide on the appeal and decide whether or not they're going to grant by way of MACCON. Now, that doesn't apply if the development was subject to the MACCON procedure before the planning authority, but in all other cases, this notification to the public of the intention to grant by way of a MACCON will have to be given. So that is, again, a departure from what we have in the current Act. And then finally, I'm just going to go through this quite quickly because I'm just conscious of time. One of the major changes in the Act is this idea that, well, we're going to impose time limits on the board for making decisions. And as any of you who have been, the subject of either an appeal or are in the appeal process, you will know that the board just can take for as long as they want to make a decision on an appeal. All they have as an objective is to make the decision within 18 weeks, but there's nothing mandating them to do that. So now, under the Act, for the very first time, time limits are being placed on the board, and they're actually contained in the Act. So for a development that doesn't require EIA or AA, the board has to make a decision within 18 weeks. If one of those applications is if one of the appeals is subject to further information, then there's a further 6-week period within which the board can make a decision, and that 6 weeks runs differently. It's either the date by which the request for further information is fully complied with, or the date where the further information request was supposed to be complied with but wasn't, or 6 weeks from the date of receipt of submissions in respect of the further information if it goes out for further submissions. It's a slightly longer time period if an appropriate assessment or in the EIA was required, and that's 26 weeks. And then obviously there's a different time period for EIA, AA type developments where there was a further information request. They've also put now a limit on a decision where there's an oral hearing procedure, and a decision now has to be made within 12 weeks from the conclusion of the oral hearing. So what the Act gives with one hand in terms of imposing these time limits on the board, it then kind of takes back a bit and says, well, while those time limits are mandatory, the Commission can still not make it within that time limit, but it has to pay a fine to the developer. And so if they don't make the determination within the period of time, they go on and they determine the appeal, but you have to pay a sum equal to a proportion of the fees as may be prescribed. So there is no default mechanism. If the board don't make a decision within time, you don't automatically get your permission or anything like that. Instead, the board still have to go through the process, but they will be paying a fine, which will be prescribed in the regulations. If they don't meet that time limit, they then still have to go ahead and determine the appeal. They still have to pay a fine, but they also have to notify the minister and the OPR. And if that occurs, the minister can request the OPR to carry out a review of the performance of the Commission and prepare a report for the minister. So that's just, again, another, I suppose, stick to beat the board would, and to try and make them comply with their requirements under the Act. Now, all I'll say is the imposing time limits on the board in previous incarnations under the Strategic Housing Development Act didn't ensure or didn't lead to a great outcome for those particular planning applications, many of which were struck down by way of judicial review. So we'll just have to see how imposing time limits on the board actually plays out, whether or not the board are going to be paying a lot of fines, and whether or not the decisions are going to be robust if the board are trying to meet these deadlines imposed under the Act. And then the only thing that I just put this up because, again, I think this is of interest. And again, it's stemming from a line of cases that are currently before the courts. And this is this idea that as part of the appeal, the developer can submit revised plans and drawings. And there's been an issue as to whether or not that can actually be done or should be done under the statutory regime. Now it's expressly provided for under the Act. So the developer can either as part of his appeal or in response to a third-party appeal, submit revised draft plans or drawings, but those revised plans or drawings can't substantially alter the nature of the development. So that's a whistle-stop tour through those various items, but there's more detail on the slide, so you'll be able to consult those at your leisure.
Thank you very much, Suzanne. Very much a whistle-stop tour, but a very insightful one all the same. Would say to everyone, there is one question there, and I have one myself. Is there a sheet with the PAP, CAP, EC, ETC information? I believe that's covered in your slides, Suzanne. I mean, obviously the Act is so big itself, so Suzanne's slides are available to everyone on this call. I suppose we don't have a huge amount of time for questions, but I would say that if anyone had any questions, they could send them into events@scsi.ie. But I would like to just kind of maybe wrap up for this, for the next few minutes. And what we're all in great anticipation of this new Act, and it's taken an awful lot of time for it to come through. But now we're kind of hearing it's going to take a long time for its implementation. I put it back to Brendan to give Suzanne a break, but maybe Suzanne could come in at the end. In a very quick kind of summary, do you believe this is going to lead to a better, it's a very loaded question, but to a better process, a better system? It definitely was needed because the previous Act wasn't fit for purpose, but has been a lot of anticipation. There's been a lot of concern about timelines and Bord Pleanála and accountability. There's a little bit of disappointment in some of the elements, but in your opinion, are we going to be operating in a better planning system in your view?
I think it'll make it worse before it makes it better.
Okay.
I think much of the dust had settled at the bottom of the glass jar that was filled with water. We knew what the rules were, and now this shakes it all up. There's going to be more turbidity for a period of time, and that period of time will be 3 to 5 years before we settle. For example, even on those remarks Suzanne made about we may need court clarification on some of these phrases. And when we get to then and have 10-year development plans, then that's when the dust settles. But it's not going to have a short-term impact, and it's certainly not going to change the frequency with which the High Court engages with legal issues arising from planning decisions.
Sure. Actually, just one question on those 10-year plans. Will they be all consistent from county council to county council, or will they be out of sync? Or do we know?
I think the idea was that they were all going to be in sync, or they would eventually sync up. It depends.
Take time.
A lot of local authorities prepared plans in 2022. So the majority of the Dublin ones are all dated from 2022. So those cohorts will all be consistent. I think ultimately the goal is that they will all kind of go along together. But that remains to be seen. I mean, just in response to your question, Lisa, I mean, I agree with Brendan. There are some very good things in the Act, some things that were probably well needed. But like anything, when you introduce a new system, people are going to have to get to grips with it. It will put, I think, pressure on the local authorities, particularly in the context of preparing these way more detailed plans. So hopefully they will get the resources that they need to be able to do that. But introduction of new concepts, say particularly the idea of it applying for permission in respect of aspects of a development that isn't known, that I think will give rise to litigation. People will try and push the envelope to see, well, what exactly can we get in there? How wide is it? I think you'll also you'll also have key phrases in the Act we're all familiar with, have regard to what it means. We're familiar now with consistent as far as practicable in light of recent judgments, but this materially consistent what does that mean? Is that going to give rise to litigation? And I know Brendan also touched on the exempted development. That could well give rise. And again, the Section 5, where it's such a big change from what we're used to, that's inevitably going to give rise to challenges, just to see how it works out. So again, I think you will see a rise in cases, but after a while, and once the dust settles then and the principles are confirmed, then going forward, hopefully it will give rise to better decision making.
Sure, it'll just take a little bit of time.
And just to pick up one theme at the back of that, like the fundamental cornerstone of planning decision making is proper planning and sustainable development under the current legislation. We've even changed how that cornerstone works in the new Act. Like that's actually fundamental. It's the keystone at the top of the arch. And we've tweaked it in a manner that I think is going to make a difference. Like it's that level of fundamental.
Okay, great. Well, look, thank you both so much. Thank you everyone for joining the CPD. It is recorded. There are slides as well, which you can take time to read in your leisure. A big subject, and great that we were able to touch upon it in such an efficient way within 1 hour. Thank you both, and thank you everyone for joining the CPD.
Thank you, Lisa.
Thank you.
Suzanne.
Thanks, Lisa.
Thank you.
Thanks, Brendan.
Thank you. Thanks, everyone.